particulars being 30th day, January 2024, at the industrial area along Lungalunga Road in Embakasi South Sub-County within Nairobi County. Otherwise, in the course of stealing, dishonestly received or retained 1,292 kilograms of high voltage harting copper, particularized in that count. The second count is the same, handling energy equipment controlling, same place, but now this time you, other than stealing, she dishonestly received or retained 330 kilograms of copper worth 429,000 shillings at the property of Kenya Power and Lighting Company. But in the first count, it was the property of Kenchaco. The third count is the same. This time, she was handling 197.5 kilograms of copper, and the property is for Safaricom Kenya PLC, or Safaricom PLC rather. The fourth count, the offense is the same, handling energy equipment, and same date, same place. This time, she was handling 134 kilograms of copper, the property of Kenya National Highway Authority, Kenya. And the fifth count is the same. This time she was handling 139 kilograms of copper belonging to American Towers Corporation, ATC. I have heard what you told the court. You are accused person together with your witnesses, and also taken into account what the prosecution witnesses told court. Get a copy of this judgment, you'll be able to read it. My analysis as follows. I have familiarized myself with the facts of this case, together with the relevant law, and to contextualize the exposition of my analysis, I set out as one issue for determination. And this is, did the prosecution prove their case beyond reasonable doubt? Perhaps the most eloquent statement of reason of this is found in the case of Winship, 397 US 358, where the Chief Justice said the following. The accused securing a criminal prosecution has at stake interests of immense importance, both because of the possibility that he may lose his liberty upon conviction, and because of the certainty that he could be stigmatized by the conviction. However, use of the reasonable doubt standard is indispensable to command the respect and the confidence of the community. It is critical that the moral force of criminal law not to be diluted by a standard of proof that leaves people in doubt whether innocent men are being condemned. Equally, in the Federal Court of the United States, in another case, this is what the court said. The burden is upon the state to prove beyond reasonable doubt that the defendant is guilty of the crime charged. It is a strict and heavy burden. The evidence must overcome any reasonable doubt concerning the defendant's guilty, but it does not mean that the defendant's guilty must be proved beyond all possible doubts. A reasonable doubt is a fair, actual, and logical doubt based upon reason and common sense. A reasonable doubt may arise either from the evidence or from lack of evidence. Reasonable doubts exist when you are not firmly convinced of the defendant's guilty after you weighed and considered all the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. On the other hand, there are very few things in this world that we know with absolute certainty. The state does not have to overcome every possible doubt. The state must prove each element of the crime by evidence that firmly convinces each of you and leaves no reasonable doubt. The proof must be so convincing that you can rely and act on it in this matter of the highest importance. Now, the prosecution case in this case is that there are 5 complainants in respect to the handling energy equipments. These materials were retrieved from a motor vehicle registration number KBZ 314S ZC 4444 from the yard owned by the accused person. It was alleged that though a licensed scrap metal dealer, she had license for some of the materials and some were devoid of any certificate. The 5 complainants laid a claim over those which did not have a certificate. Now, at the trial, none of the witnesses from the prosecution side was able to demonstrate by documentations or otherwise that indeed some of these materials belonged to them. The only markings on the gunny bags were done by the investigation officer after the complainants allegedly identified them at the sorting out area, Kawi Plaza. Now, there were concerns raised in cross-examination in respect to these markings on the gunny bags. Number one, the complainants did not table any importation or identification of copper. Number two, Kevin Otieno PW number 3 did not identify the materials but based his testimony on one Mr. Moenga, who was alleged to be an expert for Safaricom PLC. However, Mr. Moenga did not come to court and testify. Number 3, the witness did say that these materials are used by all energy sector stakeholders. They resemble. Number 4, the investigation officer said that there was an engineer who had compiled a report on these materials. However, the alleged engineer did not testify in court. Number 5, whereas Daniel Mushene, PW number 2, alleged that they had lost copper from Uruma substation, Matungulu Tala sublocation, and Nzomani and Zoyami village substation. But on cross-exam, the witnesses had not documented proof that indeed copper belonged to these particular substations or to KBLC in particular. Number 7, in any event, there was no proof that the vandalized copper from various transformers were among the disputed copper and produced in court. To the contrary, when put on our defense, the accused produced documentations as to the source of the materials in her yard. These documentations were never suspected on their authenticity. The accused called Kata Derrick from Uganda and another Joseph Mbote Karwenji from Kariobangi. And while the prosecutor did not cross-examine Kata Derrick, Joseph Mbote, upon being cross-examined, said that they sourced copper and aluminium from Lake Turkana windpipe, and they sold, among others, the accused person. This is a concern on failure to call witnesses. The IO told court that there was an engineer who had compiled a report on this material. However, he did not testify and produced that report. The report maybe will have resolved the issue of positive identification of the copper by each complainant. Equally, one Mr. Moenga Safaricom was alleged to be an expert on copper and was able to identify that which belonged to Safaricom. However, the court did not secure his testimony. Equally, Jabas Masharia, PW number 4, told court that he was an employee of ATC company, but when he was summoned, he said he assigned that work to one Benjamin to go to Kawi Plaza and carry out the identification of their copper. However, Benjamin did not carry out the assignment, neither was Jabas Masharia, PW number 4, able to identify the copper for ATC. Now, Section 143 of the Evidence Act provides that no particular number of witnesses shall, in the absence of any provisions to the contrary, be required for the proof of any fact. And so in the case of Donna Timachiwa Shilewa versus the Republic 2008, the court said that the law as it present stands is that prosecution is obliged to call all witnesses who are necessary to establish the truth in a case, even though some of those witnesses' evidence may be adverse to their case. However, the prosecution is not bound to call the plurality of witnesses to establish a fact. But where the evidence adduced barely establishes the prosecution case, then the prosecution withholds a key witness, the court, in an appropriate cases, is entitled to infer that either the said witness being called, his evidence could have tended to be adverse to their case. The same holding in R versus Bigaring Arab Koske and another 1949. Also, it is in the case of Benjamin Wagida, Itau and the Republic 2014, the same is also held. So the only inference that this court can draw from the absence of these witnesses, the engineer who is well versed with this copper, Mr. Moenga and Mr. Benjamin, is that they were very key witnesses. Their failure to come to court is an inference that they had no evidence against an accused person. In disposal, I acquit the accused under Section 215 of the CPC and set her free. Cash paid to be refunded to the depositor. And upon expiry of 14 days, the copper and all the metal materials produced in court as exhibits to be returned to the accused person. Has the other accused person come, Elias again?
Yes.
Is he there now?